Hello everyone, Kit here, back in the video. Today for you guys I'm going to be reading the Model State Vital Statistics Act and Regulations, NCHS, from the Centers for Disease Control and Prevention, National Center for Health Statistics. I'll leave a link to this down in the description box below, along with our email. You can email us at themosey@gmail.com for private consultation. And without further ado, let me get right into it. Section 1. Definitions. Dead body means a human body or such parts of human body from the condition of which it reasonably may be concluded that death occurred. I've actually already went through all these in my last video. You guys can go check this one out. I'm moving on to the next one. Section 2. Office of Vital Statistics and Statewide Systems of Vital Statistics. There is hereby established in the State Public Health Administrative Agency an Office of Vital Statistics which shall install, maintain, and operate the only system of vital statistics throughout the state. The Office of Vital Statistics shall be provided with sufficient staff, suitable offices, and other resources for the proper administration of the system of vital statistics, and for the preservation of the security and of its official records. Section 3. Regulations. The State Public Health Administrative Agency, hereinafter referred to as State Agency, is authorized to adopt, amend, and repeal regulations for the purpose of carrying out the provisions of this Act. Section 4. Appointment of State Registrar of Vital Statistics. The State Health Officer shall appoint the State Registrar of Vital Statistics, hereinafter referred to as State Registrar, in accordance with applicable civil service laws and regulations. Section 5. Duties of State Registrar. The State Registrar shall 1. Administer and enforce the provisions of this Act and the regulations issued hereunder, and issue instructions for the efficient administration of the system of vital statistics. 2. Direct and supervise the system of vital statistics and the Office of Vital Statistics, and be a custodian of its records. 3. Direct, supervise, and control the activities of all persons when they are engaged in activities pertaining to the operation of the system of vital statistics. 4. Conduct training programs to promote uniformity of policy and procedures throughout the state in matters pertaining to the system of vital statistics. 5. Prescribe, with the approval of the state agency, furnish and distribute such forms as are required by this Act and the regulations issued hereunder, or prescribe such other means for a transmission of data as will accomplish the purpose of complete and accurate reporting and registration. 6. Prepare and publish reports of vital statistics of the state, and such other reports may be required by the state agency. 7. To provide to local health agencies copies of or data derived from certificates and reports required under this Act, as he or she shall determine are necessary for local health planning and program activities. The State Registrar shall establish a schedule with each local health agency for transmittal of the copies or data. The copies or data shall remain the property of the Office of Vital Statistics, and the uses of which may be made of them shall be governed by the State Registrar. The State Registrar may establish or designate offices in the state as provided by regulation to aid in the efficient administration of the system of vital statistics. C. The State Registrar may delegate such functions and duties vested in him or her to employees of the Office of Vital Statistics and to employees of any office established or designated under Section 5B. Section 6. Content of certificates and reports. In order to promote and maintain nationwide uniformity in a system of vital statistics, the forms of certificates and reports required in this Act, or by regulations adopted hereunder, shall include, as a minimum, the items recommended by the federal agency responsible for national vital statistics. Each certificate, report, and other document required by this Act shall be prepared in the format approved by the State Registrar. All vital records shall contain the date of filling. The information required in certificates, forms, records, or reports authorized by this act may be filled, verified, registered, and stored by photographic, electronic, or other means prescribed by the state registrar. Section 7. Birth registration. A certificate of birth for each live birth which occurs in the state shall be filled with the Office of Vital Statistics or as otherwise directed by the state registrar within 5 days after such birth and shall be registered if it has been completed and filled in accordance with this section. When a birth occurs in an institution or en route thereto, the person in charge of the institution or his or her authorized designee shall obtain the personal data, prepare the certificate, certify the child was born alive at the place and time and on the date stated, either by signature or by an approved electronic process, and file the certificate as directed under Section 7A. The physician or other person in attendance shall provide the medical information required by the certificate within 72 hours after the birth. When a birth occurs outside an institution, the certificate shall be prepared and filled by one of the following in the indicated order of priority in accordance with the regulations promulgated by the state agency. The physician in attendance at or immediately after the birth or in absence of such a person, any other person in attendance at or immediately after the birth or in absence of such a person, the father, the mother, or in absence of the father, the inability of the mother, the person in charge of the premises where the birth occurred. The state agency by regulation determine what evidence may be required to establish the facts of birth. When a birth occurs on a moving conveyance within the United States and the child is first removed from the conveyance in the state, the birth shall be registered in this state, and the place where it is removed shall. When a birth occurs on a moving conveyance while in international waters or airspace or in a foreign country or its airspace, and the child is first removed from the conveyance in this state, the birth shall be registered in this state, but the certificate shall show the actual place of birth insofar as it can be determined. For the purposes of birth registration, the mother is deemed to be the woman who gives birth to the child, unless otherwise provided by state law or determined by a court of competent jurisdiction, prior to the filling of the birth certificate. The information about the father shall be entered as provided in Section 7. If the mother was married at the time of either conception or birth, or between conception and birth, the name of the husband shall be entered on the certificate as the father of the child unless paternity has been determined otherwise by a court of competent jurisdiction, or the mother and the father's husband execute joint or separate affidavits attesting that the husband is not the father of the child. Affidavits shall be notarized, and signatures of the mother and of the husband shall be individually notarized on any joint affidavit. In such event, information about the father shall be omitted from the certificate, or the mother executes an affidavit attesting that the husband is not the father and the putative father is the father, and the putative father executes an affidavit attesting that he is the father, and the husband executes an affidavit attesting that he is not the father. Affidavits may be joint or individual, or a combination hereof. Where was I? The name of the father shall not be entered on the certificate without an affidavit of paternity signed by the mother and the person to be named as the father. In any case of which paternity of a child is determined by a court of competent jurisdiction, the name of the father and surname of the child shall be entered on the certificate of birth in accordance with the finding and order of the court. If the father is not named on the certificate of birth, no other information about the father shall be entered on the certificate. Affidavits of the section shall be filled with the state registrar. Either of the parent's child or other informant shall verify the accuracy of the personal data to be entered on the certificate in time to permit the filling of the certificate within the 5 days prescribed in Section 7A. Certificates of birth filed within 5 days within 1 year from the date of birth shall be registered on the standard form of live birth certificate in the manner prescribed above. Such certificates shall not be marked delayed. The state registrar may acquire additional evidence in support of the facts of birth. Section 8. Infants of unknown patronage. Founding registration. Whoever assumes the custody of a live-born infant of unknown patronage shall report on a form and in a manner prescribed by the state registrar within 5 days to the Office of Vital Statistics the following information: 1. The date and city and or the country of finding. 2. Sex and appropriate date of birth of child. 3. Name and address of the person or institution with whom the child has been placed for care. 4. Name given to the child by a custodian of the child. And 5. Other data required by the state registrar. B. The place where the child was found shall be entered as the place of birth. C. A report registered under this section shall constitute the certificate of birth for the child. And D. If the child is identified and a certificate of birth is found or obtained, the report registered under this section shall be placed in a special file and shall not be subject to inspection except upon order of a court of competent jurisdiction or as provided by a regulation. Section 9. Delayed registration of birth. When a certificate of birth of a person born in this state has not been filled within 1 year, a delayed certificate of birth may be filled in accordance with the regulations of the state agency. No delayed certificate shall be registered until the evidentiary requirements as specified in regulation have been met. Such birth shall be registered on the delayed certificate from birth form and show on its face the date of registration. The delayed certificate shall contain a summary statement of the evidence submitted in support of the delayed registration. No delayed certificate of birth shall be registered for a deceased person. When an applicant or as defined by regulation does not submit the minimum documentation required in the regulations for delayed registration, or when the state registrar has caused to question the validity or adequacy of the applicant's sworn statement or the documentary evidence, and if the deficiencies are not corrected, the state registrar shall not register the delayed certificate of birth and shall advise the applicant of the reasons for this action and shall further advise the applicant of his or her right to seek an order from a court of competent jurisdiction. The state agency may, by regulation, provide the dismissal of an application which is not actively pursued. Section 10. Judicial procedure to establish facts of birth. If a state agency registrar refuses to file a certificate of birth under the provisions of Section 7 or 9, a petition signed and sworn by the petitioner may be filed with a court of competent jurisdiction for an order establishing a record of the date and place of the birth and the patrons of the person whose birth is to be registered. Such petition shall be made on a form prescribed and furnished or approved by the state registrar and shall allege that the person for whom a certificate of birth was sought was born in the state. 2. That no certificate of birth from such person can be found in the Office of Vital Statistics or the office of any local custodian of birth certificates. 3. That diligent efforts by the petitioner have failed to obtain the evidence required in accordance with Section 7 or 9 of this Act and regulations adopted pursuant thereof. 4. That the state registrar has refused to file a certificate of birth. And 5. Such other allegations may be required. The petition shall be accompanied by a statement of the state registrar made in accordance with Section 7 and 9, and all documentary evidence which was submitted to the state registrar in support in such registration. The court shall fix a time and place for hearing the petition, and shall give the state registrar days notice of said hearing. The state registrar or his authorized representative may appear and testify in the proceeding. If the court finds from the evidence presented that the person for whom a certificate of birth sought was born in the state, it shall make findings as to place and date of birth, patronage, and such other findings may be required, and shall issue an order on a form prescribed and furnished or approved by the state registrar to establish the court order certificate of birth. This court order shall include the birth data to be registered, a description of the evidence presented, and the date of the court's action. The clerk of court shall forward each such order to the state registrar not later than the 10th day of the calendar month following the month in which it was entered. Such order shall be registered by the state registrar and shall constitute the court order certificate of birth. Alright guys, I'm going to end it here. I'll see you guys in the next video. I'm going to make a part 2 to this. Like, subscribe. I'll see you guys later. Bye.